Well, welcome to the 2009 Coase Lecture. Thank you very much for coming. I never know with the Coase Lecture whether first-year students for whom the lecture is designed feel that secretly we take attendance and they're required to come, or perhaps they think the Coase Lecture will be on their final exam. True, they might well be. Or they somehow come because they know they feel affection towards one of their teachers. In this case, our Coase Lecturer for the year, Professor Omri Ben-Shahar. I like to think that it's some combination of all three, but maybe with 99% of the weight on the third of them. But we'll find out. We'll see the reaction, and we'll see the final exam, and then we'll know which it was. So it is our tradition only to have very, very short introductions, and I'll follow that tradition. I will just point out the logistics at first, that a rare event for the law school, we will actually let our Coase lecturer lecture without interrupting him with questions. Normally on Tuesdays we have law and economics workshops, and he might fear that we will jump in with, "That's the craziest thing I ever heard," after about 30 seconds of the lecture. But we're going to experiment with sitting politely and listening to the lecture itself, and I'm sure it'll be a real treat. Though he will, as is our inviolable tradition, leave plenty of time for questions at the end, and you just raise your hand and he'll recognize you, and we'll have a fair amount of time for questions. Afterwards, I forgot to check, but no doubt there is the usual supply of absolutely free food outside afterwards, to which everyone is invited. So please come on in and don't be shy. Just come on down and find a seat. Professor Ben-Shahar has not been with us very long, but I feel like it will seem like he's been here for a long time because his work is very much, I think, in the spirit of Chicago. I remember when I was a young professor, the word on the street was, meaning the word in the law and economics street was, that contracts was a dead field. In academics, that means that, of course, contracts are important and everybody should take it as a student, but that it's dead. I mean, everything interesting had been written in it already, and there were plenty of articles and lots of books, and law and economics had gone there and done its thing, take 4 or 5 tools and spray them around with machine gun fire and apply it to everything. And young people were advised, if you want to work in law, stay away from torts and stay away from contracts. They are dead fields. They're fully, plucked, or whatever the right metaphor is, and go somewhere else. And sure enough, people started moving to other fields. But here, the proof is in the pudding. Here, defying all expectation, our new colleague comes and slowly but surely looks around the area of contracts and writes about boilerplate and mitigation and default rules. And I brought along the list as if I needed to look at it, but options and this and that. And everywhere he looks, he finds something really, really interesting and novel to say. And I think the accomplishment is all the greater given this claim that, that's written about already, go away and find something else to write about. So let this be an inspiration to all of us that we can not only look to new fields of law in which to write, but we can go back into areas that are supposedly well-mined and find all sorts of interesting, sometimes contrarian and sometimes just correct things to say about them. So with no one more eager than I give you Professor Omri Ben-Shahar.
Thank you, so very generous. So what's more corny, more predictable than to talk here at the University of Chicago Law School about the fact that consumer protection laws and the consumer protection movement is replete with myths, and that it has the consequences it wants to achieve are not as attainable as it. That's the idea of the myth, that it doesn't really accomplish those consequences. Surely, if some consumer protection advocacy group saw the title of this lecture, they said, "Oh, we know what they're going." Sitting there in Chicago, we know what they're going to say. They're going to say that all of the things that we're doing for consumers just don't work. Now, I wish I could come here today and tell you that, introduce you for the New Year's and my colleagues to this just new movement coming out of the pipeline, these PhDs being sped out of the schools with a brand new methodology of studying consumer protection, new ideas, new way to figure out what works and what not, and get great results, and we should all switch to that. No, this is not what I'm going to say today. In fact, to some extent, I'm going to live up to the prediction of the Consumer Protection Advocacy Group that they already know. But I hope that going through some of the basic ideas and discussing their potential to basic ideas of consumer protection and discussing why we think they might have potential and in what sense they have, even before checking the data, they have serious flaws. Of course, the data needs to inform the understanding of the magnitude of these flaws. We want to be skeptical. So this is a part of the tradition of the skeptical law and economics movement that says that things that seem to be ammunition that seems to have long range is not that powerful. Okay, let's get to let's start exploring some of the ideas. So before I talk about the three myths that I asked to put on the poster, information, litigation, and access, let's briefly remind ourselves what the field is about, why consumers in the marketplace dealing with businesses, why do they need protection, and there's a sense that we know why they need protection, and also that we know what needs to be done in order to bolster the rights of consumers in the market. They need protections because they need protection. After all, consumers get their services and goods that they buy in the market in contracts, and they have contractual rights. But the sense is that remedies for breach of promise are not enough in these contexts to protect them. It is like it's kind of a metaphor. There are so many corny metaphors. David is fighting Goliath, but this time is not winning. A sling and a stone from the brook is not enough against the modern-day Goliath. Something else is needed. For example, in 1962, President Kennedy declared that if a consumer is offered inferior products, if prices are exorbitant, if drugs are unsafe or worthless, if the consumer is unable to choose on an informed basis, then his dollar is wasted, his health and safety may be threatened, and national interests suffer. So that's why the field matters. Now, many people here, seasoned scholars of the law, know that any topic that you start, you can find some presidential statement or somebody important said that this is an issue of national interest or that this is the most important, the most difficult solution. But I think that this is beyond the generic statement. There is a prevailing sense that you hear often, and you want to take seriously, that consumers are in need of some kind of help when interfacing with businesses. As to what to do about it, again, there is a sense that we kind of know what to do. In fact, President Bush might surprise some. A few years ago, 2006, declared National Consumer Protection Week, committed to the vigorous enforcement of the consumer protection laws. Now, that could teach us that we know what to do, so much so that we have it all in a week. We have a vigorous enforcement in a week. We already figured out what to do. We just need to concentrate it. Or maybe that it's all just rhetorical lip service. But it's not just rhetorical lip service. There are many ways in which consumers' rights can be bolstered, and that I'm not going to talk about. There are tort suits, not just for injuries and product-related injuries, but tort suits in many states that are not limited by the economic loss doctrine, where can get recovery for consumer-type losses, pecuniary losses. There are consumers can bring private attorney general suits under Consumer Protection Acts, under states' little FTC acts, where they can get all sorts of very generous remedies. We'll talk about that. There are ways to enforce consumer rights that are not driven by consumers, such as by the FTC, by agencies, by state agencies. But again, the sense is that those are intended to deal with, largely to deal with, systematic abuses that go maybe beyond the typical breach of contract, where the consumer is disappointed because of something maybe that is not systematic that was breached, and that was not criminal, maybe was not intentional, was not deceitful. You know, contract gives you rights and remedies that are independent of the intent to perform or not to perform. Kind of strict liability guarantee that things will go well as promised, and they didn't. And the consumer is disappointed, cannot use these tools. And so the focus will be on other tools that are that within the consumer protection context could perhaps bolster and help consumers improve their position vis-a-vis businesses. And I'm going to talk about disclosure of information, about contract enforcement litigation, getting access to litigation, and about the idea that remedies and enhanced remedies are what consumers need. In all three cases, I will explain what exactly the idea underlying these consumer protection devices are, and then why I think that they are not as promising, to say the least, as they pretend to be. Now, I plan to spend a little bit of time talking about what is the reality that consumers are dealing with. I think maybe I'm not going to spend too much about that. You know, there are various kinds of runarounds that consumers get from business. You know, starting from the most mundane thing of calling the consumer 1-800, the producers or the business 1-800 warranty number, and not getting anyone after several tries and long hours, long wait. Nobody answers. The problem is not solved. But it's beyond convenience. It's about all sorts of surprises, unpleasant surprises that consumers encounter when they deal with businesses. Hidden fees, delayed charges, escalating charges, things that were not made as clear to the consumers, and they are genuinely surprised. You know, it's in the context of the present financial crisis and economic crisis, it is interesting that perhaps what we're talking about right now is at the core, according to some accounts, it is at the core of what's going on. The driving force for the problem we are seeing are the mortgage contracts that consumers entered into. Now, these contracts are regulated in many different ways, and we're not going to discuss them. And maybe the problem is a regulatory problem. It does not arise necessarily from the interface between the consumer, borrower, and the lending institution. But the fact is that consumers found themselves in a very unpleasant situation, and helping consumers now is part of the solution that is discussed. But discussed not only in ex post factum, but also to think about how the problem emerged, entering into contracts in which it was not clear to many consumers that things can go bad. Perhaps we can debate whether this was done in a way that businesses could have prevented, but in many other contexts of consumer credit, it is clear that the businesses use techniques of hidden fees, delay charges, and things like that to get consumers to make decisions that are not optimal for the consumers. That's part of the reality that exists. Other parts of the reality are things that have to do with consumer privacy, information, especially on the web, misleading information about what the package includes, beautiful picture of the cruise or the hotel where the reality is not as nice. And for contract, since this is a legal audience, part of the picture is not just in the product, but is in the contract. The problem of the hidden terms, quote-unquote hidden terms, the boilerplate contracts that consumers end up accepting with the product that contain all sorts of limitations and different techniques in which consumers find that the value that they expected to have at a particular contingency has been disclaimed or contracted away. Now, there's an additional preliminary one, myth number 0, about what's going on here and how to fix it, has to do with competition. The reason we have all this problem is that there is no competition. monopolies, big, strong parties with with all the bargaining power are the source. There is a nice quote from the case by the New Jersey Supreme Court about the fact, case in auto contracts between buyers of automobiles and the manufacturers of automobiles. Manufacturers, the court said, are few in number and strong in bargaining position. Because the consumer's capacity for bargaining is so grossly unequal, the inexorable conclusion which follows is that the consumer cannot turn to a competitor for better protection. Thus, there is lacking a factor existing in more competitive fields which tends to guarantee the safe construction of articles sold. So the problem is competition. That doesn't make sense in many ways, and I'm not sure we have to go through all of them, but at least two I want to quickly mention. A monopoly with the unlimited, not at the least disciplined by market competition, would not have the incentive to provide consumers with products that are less safe and of lesser quality than a fiercely competitive manufacturer, for the simple reason that the monopoly would make more money by making the same product the efficient or the high quality product that the consumers are willing to pay for, and charging more, using the monopoly power not to reduce quality but to increase price to the extent that quality is a price, that the cost of this quality is justified by the price. So that's one reason why it doesn't make sense, a very basic economic reason. It is also probably wrong by looking around and seeing that the problem is not, a kind of anecdotal empiricism. The problem of lousy boilerplate and hidden fees and all of the things that consumers care about are not problems that have to do with non-competitive markets. They are not competed away when there is fierce competition. Credit cards are competitive markets. Hotels are competitive markets. Cell phones compete vigorously, compete down and provide many attractive features. Computers, airlines, they're all competitive markets to a large degree, and the problem is no lesser in those situations. So if it's not, and I claim it's not bargaining power, what is going on and what can be done to help consumers? We'll talk about, I said the first thing that I want to, the first myth is information. Now, the problem of information is not a myth. It is true that consumers just don't know what it is that they are accepting when they enter into even simple transactions. They have all sort of contingent provisions and aspects that consumers just don't know. And it is the way to protect consumers, according to this account, is to improve the information that they have. The workhorse of consumer protection in the 20th century is disclosure. That's not my statement. It is a statement that is broadly accepted. And if you look around at consumer protection, you see that most of the legislation that has been passed in states has to do with what we call mandated or mandatory disclosure. Disclosures that have to be done by the business to the consumer. It's easy to understand. I spent last summer reading a lot of these mandated disclosures. In fact, hundreds of them just in Illinois and California. There are many hundreds of mandated disclosure statutes in different areas mandating what it is that the business has to disclose to a consumer. And you kind of scratch your head and think, and ask yourself, why is there so much? And there is probably a simple political economy story to be told. It's very easy to pass these things. The seminal mandated disclosure statute that was passed by the federal government, the TILA, Truth in Lending Act, was passed by overwhelming majority in Congress. Who would oppose? If you want to help consumers, this looks like you're doing something. If you believe in free markets, you might say to yourself, well, you don't really need mandatory disclosure. The market will lead to voluntary disclosure whenever it's helpful. But it doesn't hurt. It doesn't hurt that much to mandate it. Maybe it's redundant. That disclosure would be redundant. The market would provide it anyway, in which case it's not harmful at all. Maybe it's not redundant, it's just unnecessary. It's a small cost, and it's easy to generate coalitions to agree on these things. And remember, it leaves everything else unregulated. Quality, price, entry. So a consensus is easy to create, and it explains the broad existence of the statutes. Again, we could spend hours going through. It turns out it could be a fun experiment to go and see what these things are, where the mandated disclosure statute, what do they require. I kind of enjoyed myself, to my surprise, over the summer when I was reading those lengthy regulations and legislation. I'll give you just a small taste. I mentioned TILA, the launching event, so to speak, of of mandatory disclosure in the U.S., where the lenders, where creditors have to disclose information about the APR, the annual percentage rate, the total amount paid, the options for prepayment, all sorts of charges. This is prevalent. It was extended to many other consumer credit areas, credit cards, bank deposits, investment accounts. It was extended to areas of credit that are aimed at banking the poor, or credit for the poor, services, financial services like pawn shops, payday loans, rent-to-own businesses, retail installment sales. Those create significant problems for consumers of these services, and by and large, the solutions, there are additional solutions, but the workhorse, again, of the solution of protecting consumers here is mandated disclosure of things like the financial terms. It also extends to mortgages. It's important. That's another consumer credit area, but it's worth pointing out because of its recent importance. We realized that there were a lot of mandated disclosures in all of these mortgages that consumers took that are at the basis of the financial crisis that we are experiencing. Clearly, they didn't work. I mean, we'll talk about the data in a moment, but we know now that no data will persuade us that those mandated disclosures helped consumers make rational, efficient decisions. That does not slow down the disclosure movement. If disclosure 1.0 didn't help, maybe disclosure 2.0. So now we have quickly emerging proposals for reforms in academic scholarly papers talking about how to improve mandated disclosures in the mortgage context, an all-inclusive APR, so that people will know what the APR really is, not what it is upfront. Some version of the 2009 model of mandated disclosure. It is still very much what the government does in this area. In other areas, insurance, many people know that when they enter insurance agreements with a policy, there are all sorts of disclosures that they are exposed to. The insured's in Illinois has a Bill of Rights for homeowners insurance, where the insured has to receives that. Medical insurance, the HIPAA disclosures that we all sign so frequently, mandated disclosure. In a context of goods and services, there are plenty of things. Funeral services gave rise to a lot of problems for consumers and a lot of disclosure statutes about what is included, what's not included in the pre-need funeral contract or in the contract to purchase a casket. Here's just one thing. In California, there is a disclosure that requires that the seller of a casket to inform the consumer that, I'm reading, in bold, in all caps, there is no scientific or other evidence that any casket with a sealing device will preserve human remains. So you imagine the value of some of these things. When dog dealers sell dogs, there is a disclosure of the buyer's right to return. It doesn't sound so good. Unhealthy or dead dogs. Car dealers, in the context of car contracts, disclosure of odometer readings. Anyone ever bought a car without checking but just in case. Towing services. When a towing service arrives, they have to first disclose to you various aspects, pretty long list of things, itemized fees, policies, prior to towing the car, all to protect the consumer and give the consumer an ability to make a more informed choice. Fine arts, when you buy fine art, there is a disclosure statute that mandates, that requires to disclose the identity of the artist and the medium of the art. Vocational schools, this have to disclose sometimes up to 20 statistics about past graduation rates, re-enrollment rates, exam passing rates, job prospects of past graduates, and so on. Restaurants, we all see, have to they have to disclose that consuming undercooked food or Caesar salad or oysters could be all sorts of things that might be dangerous for us. They are regulated. So this is, how do you give a sample of what it is? You can call it a disclosure republic. This is only the tip of the iceberg. In many other contexts, go beyond consumer commercial transactions. We believe in mandatory disclosure. Miranda warnings are mandatory disclosure. Informed consent in medical context, in medical services, is mandated disclosure. The opportunity to read contracts and a lot of many things that have to do with basic contract law doctrine are mandated disclosures. Surely the idea is information can do no harm, and so why not require it? It can help some. It might do no harm to others. I think that that's not the case. I think, first of all, it doesn't do any good. By and large, does no good, and it could even backfire. It doesn't do good, and the reasons have been explored broadly by through many perspectives and methodologies. First of all, many of these disclosures are impossible to understand. So TILA, the seminal statute, here is a term that has to be disclosed. I think it's important to hear it once, at least once in your life. Unearned finance charges are computed by calculating for all fully unexpired monthly installment periods as originally scheduled or deferred, which follow the day of prepayment, the portion of the pre-computed interest that bears the same ratio to the total pre-computed interest as the balance scheduled to be outstanding during that monthly installment period bear to the sum of all scheduled monthly outstanding balances originally contracted for. So you might say to yourself, okay, maybe you can improve these things. Disclosures that just give you the gist of it. Like, Google does in their click wraps or their contract, their boilerplate. Well, here's eBay was the first one on the web to use this really nice, simple language, contract language and disclosures. And here's a sentence from eBay's contract with the users. When you give us consent, you grant us a non-exclusive, worldwide, perpetual, irrevocable, royalty-free, sub-licensable, through multiple tiers, right to exercise the copyright, publicity, and database rights, but no other rights you have in the content in any media known now or in the future. Now, this is understandable maybe to maybe to many people here, but to very few people outside this room, and I would imagine that if I asked, picked on one of my students here and tried to figure out together some of these terms, it's not that clear. Judges, again, the New Jersey Supreme Court justices in a famous case, an insurance contract, said, I don't understand what it means. And they all said, yeah, I don't too. The three judges sat at the panel and kind of collectively confessed that they never understood what their insurance contract says. It says one thing and then the opposite. People can't understand, and there are many reasons, and I wish I had more time to kind of go through more of the reasons why we don't understand. It's not just the language. It's the conceptual issue. With probabilities and risk, these things disclosures deal with probabilities, they deal with risk, and we don't really know where it's a big field that shows that people don't understand how to think about these things in a way that leads them to good decisions. Many of these disclosures involve complex concepts that are, again, difficult to make, difficult to understand, even if you had a long tutorial about them, disclosure about a choice of forum that will go to Virginia instead of state of Washington. What does that mean for me? Even APRs, studies show people have a hard time understanding. Many of these disclosures are disclosures of packages, and it's hard to figure out what to think about the entirety of the package. Furthermore, we might understand that the package we are getting is not so good, but the price is also not very high. How do we compare this package to another one that's better but costs more? Make price quality or price term comparisons. It's maybe easy to know when you buy an iTunes track and you're willing to pay $1.29 instead of 99 cents to get it free of some legal terms and DRMs. But when you talk about complex credit transactions, it's much more complicated. Many times the disclosures are mandated at the end, right before entering the transaction. This is too late a time to walk back and say, no, I'll go back and start shopping around. And even if some disclosures work, it is, think about it, we have so many. Can imagine and can go spend a couple of minutes humorously describing the day of a consumer that takes seriously these disclosures and wants to read them. Every website has a disclosure of terms, mandated. And so it is just too many. And then part of this term that we will see is a modification clause that allows them to change the terms. So we have to keep up with the modification. It's just too much. It's many various aspects of information overload. There is a lot of, I don't have time to review the data, but there's a lot of evidence that this is not working. I'll just give you one crispy bit of data. Just yesterday I saw a new study of clickstream data from internet behavior on the web of consumers that actually look to buy software on the web. They go into the website, and when they decide to buy, at some point they have to look at the term. How many people spend time? The data shows us how many seconds you spend on each page, including on the terms and conditions. It turns out that the number, in a paper recently, I labeled, without seeing any data, I said, all these disclosures help maybe the 1 in 1,000, metaphorically speaking. The data shows that among study of 65,000 consumers, 1 in 1,000 actually visits the page, spends a few seconds on the page with the terms. We don't know if they read. The average amount of time for those that visit the pages with the terms is 40 seconds. Now, the average number of words is about 2,500, so they can't read. It took more than 40 seconds to read one term, not to mention digesting it. So 1 in 1,000 now gives us the max. It can't be more than that. I would say that it's probably much less than that. No one reads it. No one reads these contracts that we are giving people an opportunity to read through the mandated disclosure. So that is one myth, a myth of information. Another myth that I want to discuss has to do with access. There is a notion that part of what's going on, this is a distributive idea. Not so much an efficiency claim, but a distributive claim. That some people don't get access to those primary goods that we value in a democratic society. So we have public parks and public education, and we think that they should be open to everyone. There's a sense that it's a good virtue to a just and democratic society to create access to many of these things in an equal way. And if you believe in these things, some consumers are deprived access to what? For example, they're deprived access to courts. We have the public courts should be accessed by everyone. And it turns out that there are all sorts of tricks that businesses use to stop access, like mandatory arbitration clauses that force aggrieved consumers to go away from courts, can't enter courts and get remedy or recovery for in their complaint, can't vindicate their rights. It's a language of a democracy. And so we have to mandate equal access. Similar ideas are discussed in the context of access to the internet, in the debate over net neutrality. Should it be equal to everyone, or should it be priced so that some people will have to pay more, or some businesses would have to pay more? Equal access to markets. in the European Union, which is leading the way in finding new ways to protect consumers against businesses, there is a new version of, like, the equivalent of our UCC, Uniform Commercial Code, that is now circulating across the member states of a Uniform Commercial European Code. And one of the innovations that is mandated by the agreement of the Union regarding consumer protection is that consumers must have a right to return to the market after they made a purchase in sales contract, and no immutable, non-disclaimable, mandatory right to return the goods and withdraw from the contract. A reasonable one, not forever. Access to the market. Now, again, this it sounds, in many contexts it sounds good and can be defensible, but I think that there is an element here which make me think of it as more as a myth than as true value. And it has to do with the question of who uses the right to access. Everybody has it in potential, but do people systematically, is there a systematic way in which it is used or not used by some people? If all people have the access, but very few people use it, but everybody pays for it, then we are confronting an interesting dynamic that we economists call a cross-subsidy. Those that don't use pay for those that use. Imagine, just metaphorically, that there was a crazy regulation, but just to get the point, that airlines had to make their first class section in the front open to all passengers, and everyone the first come, first serve. And so your ticket price would be a little bit higher because you will pay for the chance to sit in the first class, but it might turn out that it's not really allocated randomly. Some people whose time is worth less, or for some reason have can get premium access, and whereas others can't. You can see how those that systematically get less access to those first-class seats pay and cross-subsidize those, and might say, we don't want this regime. We want to buy our old cheap tickets without the right to access. So when it is now, sometimes those that systematically overuse the right to access are poorer individuals, and we think that is a good idea, that they'll be cross-subsidized. Maybe that's why we have open public access to parks and to education. It's being cross-subsidized, and it is a valid distributive idea. I have nothing to say about that. But when the access is used more by elites, it is the elites that are being cross-subsidized by the non-elites. Access to litigation, I would argue, benefits the consumer, the relatively more sophisticated consumers who can find a lawyer and can figure out that they have a claim and they can vindicate it. Barring this litigation and sending everybody to mandatory arbitration eliminates this cross-subsidy and might do well for consumers generally. They don't have to pay for this cross-subsidy. And so in the pretense of a democratic redistributive idea that works in many contexts, we might import it into the consumer protection context, and that might not work as well. Now, I have not planned well, and I want to stop and take questions. I'll just explain briefly what I'm not going to talk about. So I'm going to talk about what I'm not going to talk about. The third myth had to do with increased remedies for consumers when breach occurs, and I was going to suggest a thought experiment. I would say, suppose we had this crazy world regime in which consumers who enter contracts with businesses enter it's a new regime. Let's call it one-way contracts. They're only enforceable one way, but the wrong way. They're only enforceable by businesses, not by consumers. You have zero legal rights under the contract. The business can sue you for payment and for all the terms in the contract, but you can't sue the business if the product is defective or if never delivered or delivered defectively. Just no contractual remedy. Why would that make any sense? I'm not necessarily suggesting that it makes sense, but I think that it's not the end of the world. There are many ways in which consumers will get protections. I don't want to call them market protections. There are all sorts of sophisticated or simple devices that could emerge to protect consumers, they don't really need the right to sue that very few use anyway. Their transactions might be redesigned in a way that it puts less at risk for consumers. Instead of buying a gateway computer and then trying to sue and get damages, that doesn't work very well. That was the experience of many gateway customers. You will maybe have to protect yourself, knowing that you don't have any legal right against gateway, carve that transaction into pieces, rent one, and pay on a monthly basis with the right to terminate at any given time. Create more transaction costs, but hey, this is the Coase lecture, transaction costs. The idea is that maybe there will be ways to figure out, innovate on how to reduce transaction costs. There might be a right, instead of relying on legal remedies, we might want to rely on reputations. And we see that. You go to restaurants, there are no suits. I've checked it. There are no contractual suits, almost at all, against restaurants. There are 0 suits against taxis. There are almost no suits based on breach of contract against supermarkets. We go to these places based on their reputation. Restaurants, very easy to check reputation, maybe more difficult with taxis. But we do pretty well protecting ourselves by looking at ratings and at sharing information, aggregating information. So the idea is, maybe the way to think about consumer protection is not bolstering the legal remedies, but eliminating the legal remedies so as to direct our attention to other ways in which we can, quote unquote, manage our claims against the businesses that misbehave. Okay, I'm going to stop here and be happy to engage in question and answers. There.
Well, I really enjoyed this talk. I was wondering if this would apply. Well, I had 2 points. One was insofar as access to courts is concerned, there's a movement that just like we have Gideon in criminal law, we could have Gideon in civil law. There's a civil Gideon movement going on, which would say that in civil suits, people should be able to have access to courts as well, being paid for just the way they are in criminal suits. I was wondering what your thoughts on that were, because if that's true, then there would be no access problem. Then you would literally have everyone go to court in civil cases. I can see there's a tax problem there, but I just wanted you to consider that. And then the second point was, wouldn't this hold true, the disclosure, the uselessness of disclosure, wouldn't it also hold true if the market took care of it? Then the market wouldn't provide it if the consumers don't use it, right? And it would also hold true in the case of the government, because the government publishes all these reports and like floor debates and so forth. People don't read those either. Courts write opinions that people don't read either. So we have all this information in other domains which people don't consume either. So should those also be blocked off for the same reason?
I think that there is a problem. When you talk about consumers, I think that the issue of information is overvalued. I think when people engage in transactions, commercial, simple purchases, all the way up to medical contracts, where they go to the doctor and get service for their medical needs, we focus a lot on information, but my premise or my conclusion from looking at these things is that individuals don't want information. They want satisfaction, fulfilling experience in that particular context. Having to make more informed choices doesn't necessarily, and sometimes it reduces the amount of pleasure that you get. I don't want the doctor to tell me about, maybe other people feel differently, tell me about all the possible situations and try to help me figure out what the true risks are. I want the doctor to tell me what he or she think is based on their experience and with a sense that they have empathy for my situation, what is the best course of conduct for me. So that is the information I want. It's a very different kind of information, and it can be compacted into something that I can understand and I don't have to process. Yes?
Today we have a large segment of the population that's functionally illiterate. There are many consumers who simply don't read. I wonder whether the medium of communication, whether it's oral or written, is significant in the law. I don't have a contracts background. And I also wonder whether or not it's time to have a Miranda rights of sorts for those who enter into mortgages, whether that oral transmission of risks in this compacted sense of what a contract entails can be mandated, and whether it's practical in the marketplace.
Yeah. You know, it is, you can imagine a regime, an utopic regime, where you sit in front of a loan clerk at the bank, and they look you in the eye, and they understand your needs, and they say, look, I know what's going on, there is all this stuff you should understand, it's a lot of money, it's going to grow over the years, for most people it doesn't work, give you the kind of oral, empathic advice, disclosure that would work. And I think that this would not be a myth. This is the idea that I have for my doctor. That's what I ask my primary care physician to do for me when I go and sit with them, not to read to me something, you know, some boilerplate stuff, but to do this eye-to-eye thing and give me the gist of it from okay. The problem is that if we try to regulate this into something that's oral rather than written, it would do what one of our colleagues here, Judge Frank Easterbrook, described in one of the cases as an operator anesthetizing the consumer by reading a pre-printed list of disclosures. So the written would be read to you by someone whose job is to read it hundreds of times a day, and it no longer any solution to, in fact, you would say, as I say in this situation, try to say, stop, please don't read it to me, send it to me at home, it's good enough. Where I can, instead of waste my time, just discard it. And remember, I discard it not only because I think that this information, what I hope to find in many of these disclosures are bad terms as a consumer. These are bad terms because I know that the good terms, I am one of those consumers who are systematically less likely to invoke them. If I'm unhappy, I'm not going to sue, I'm not going to call an 800 number, I'm going to buy another product, maybe because I can afford to. So I'm not making a progressive, regressive argument here, but I'm saying that I don't want to pay a dime more for good boilerplate terms that I'm not going to use. So again, maybe you can get a disclosure that will help you distinguish between the good and the bad, but gee, you really don't know if what you want to hear is good or bad. Evan.
So you seem to insinuate that consumers don't necessarily pay attention to disclosures and things of that nature, but then in the section that we didn't quite talk about, you sort of infer that we're going to rely on reputation as a potential alternative, even though reputation, though maybe more attenuated, is based on aggregation of information and things of that nature. So my question is, do you foresee that disclosure laws, even though maybe not beneficial to consumers, are still a necessary evil for those people aggregating information and reputation based, or is it a different form of information that we're getting at with reputation, something that's more experiential or qualitative in nature?
So I think I don't have a lot of systematic knowledge other than anecdotal on what the value of the aggregating rating informations. You know, I kind of look at them with curiosity every time I see them. The Zagat ratings for restaurants, Expedia's star ratings for hotels, and things like that. What do they aggregate? They aggregate things that are, by and large, not what are subject to mandatory disclosures. They aggregate things, you know, that they describe the prior consumers' satisfaction. Now, you don't know if they are representative. There might be all sorts of problems. Maybe 5-star doesn't mean really 5-star. But you get a sense of comparative quality across comparison shop, that you can do comparison shopping that you would otherwise be unable to. I find this to be a very powerful tool, and you know, increasingly it is recognized and it is used by more consumers. In the end, the disclosure could be, you might want really good terms, a really generous warranty, and you get it from the disclosure tells you that you have it, but the reality is that the seller or the business gives you the runaround, and it's not easy to invoke. Whereas in a different business, you get no warranty, nothing. But if you have a problem, they take care of you. You want to know that too. So there is the actual experience that is filtered. It's the the baseline is what you get in the contract, but that has to be filtered through the actual practice, and that actual practice might vary significantly. And those ratings give us information about those things. Yes.
So to continue on the myth of information, it seems like you don't, and I think it's pretty clear that individuals don't check these policies every day, but what about those people that have a particular concern, like consumer interest groups who would check these policies every day and then sort of create a public outcry to force change in the policies and thus get better terms for the consumers through being able to see the disclosed policies?
Mm-hmm.
And if that, you think, has any role to play in sort of decreasing the disparity in bargaining power between the consumer and the corporate entity, and whether that may be a good use for disclosure or not?
Yeah, so we have readers that might do the work, be agents for the rest of us by reading, either behaving on the basis of what they read or disseminating this information to people that don't read. The question is, how do they disseminate to people that don't read what they disseminate? But supposedly there are ways to translate it. I think that's a myth too. I think, first of all, readers, the few sophisticated readers that will comparison shop the terms, the disclosures, and because of they discipline the business. That's a long-standing myth in law and economics that they exist and that they do that job. If the data that I mentioned to you before, the 1 in 1,000 is a reader, there is no way that that's enough. A smart business would say, I'd rather lose that 1 in 1,000 and not give good terms just to please that 1 in 1,000. That 1 in 1,000 will not discipline the businesses. Now, maybe you said consumer watchdog, watch groups that would read it, analyze it, and kind of create some kind of a rating or a seal of their own approval. Well, sure. For that, you probably don't need much mandatory disclosure. They're sophisticated enough to get first of all, to get the information without mandatory disclosure, and secondly, to understand that what is disclosed is not the end of the story. They want to know how it is filtered through the experience of people and disseminate that. You don't see a lot of watch groups and consumer advocacy groups go around and tell you what is in the boilerplate. They go down and tell you, watch out. What you promise is deceptive. That's not what you get. It's not the choice of forum clause or arbitration clause that they inform consumers about. So again, that is another layer of skepticism. Yes,
I'm just curious, what is really consumer protection? I mean, what would be a good regime for consumer protection? It couldn't possibly be a system where there is perfectly safe goods, because they will be too expensive. And that's why I'm just wondering, what are we really trying to achieve when we talk about consumer protection? And I'm just wondering, perhaps things like mandatory disclosure and remedy is just a way to help, like a comforter, to help people get over with the loss when bad things happen. And it's a cheaper way than a doctor who can empathize with the patient and say, I need to tell you this. Rather, it's a general way to make people know that, yeah, the information is out there, bad things happen to you, too bad, you should have read.
So I think, this is the question that I'm struggling with. If those are myths that don't work, what does work? The direction I think my thinking goes is in two polar ways. And I think it's a mixture, for me, probably of the two directions. One is to say, is a very much a Chicago thing to say, we don't need much regulated government, over-intervention by the government in all these clumsy ways. There are just find ways to make those market devices, like private bonds and assurances, private rating systems, help consumers figure out what's going on. They'll use their right to refuse to enter business, the right to boycott businesses that are not good. So that is one, that helps. And we see that with the emergence of rating systems through the web, there is a lot of good that happens to consumers, and a lot of types of services flourish because consumers feel more confident using them directly. But that's not the entire story. With mortgages, that is probably not the entire solution. What do we think would help consumers make in the future better, borrowers make better decisions that would not repeat their catastrophic mistakes that were done in the last 15 years? No, I don't think that tort liability for reckless lending is the solution. I do think that, and I think many people might agree now, that there are some limits on the freedom to choose and to make mistake is called for. And so to say, if a government wants to regulate, to protect consumers, say, there are things that you can't get. And lenders will be in trouble if they give it to you. There are, so regulation of quality and regulation of the volume of transaction in this context might work. So the point here is that sometimes we have to get our hands dirty and say to consumers, these are things you just shouldn't be buying in the first place. If it's not the information, it's not how you process information about them, just throw it out altogether and help consumers in that way. How much am I willing to go and defend any particular policy? I'm not sure, but I think that is part of the mix. It's not just market devices and ratings and the reputation. It is, of course, this is part of it too.
So I don't understand you to be taking the position that disclosure is never good, right? So let me give you a few examples that I think ought to be uncontroversial. Lawyers must disclose disciplinary proceedings against them, right? That's a disclosure that information aggregators like Avo use to help consumers decide which lawyers they should pick. And in the absence of a mandatory disclosure regime for these records, clients are going to have a harder time differentiating between good lawyers or bad lawyers. This candy bar contains peanuts. Okay, mandatory disclosure. I ignore it because I'm not allergic to peanuts, but I have a friend who is allergic to peanuts who finds it extremely valuable. And prior to FDA involvement, the level of disclosure wasn't always optimal in terms of cost-benefit analysis and the risk posed to people with allergies. You give, I think, the excellent example of mortgage regulation and disclosures as part of the Truth in Lending Act. It's certainly the case that that disclosure regime was horrible, but one of the criticisms of it is the disclosure regime is horrible because borrowers got the information 10 minutes before they're supposed to sign a document agreeing to the closing and handing over the keys. There are people in the industry who argue this disclosure ought to happen 2 weeks ahead of closing, 3 weeks ahead of closing, not the day before the would-be home buyer's lease is about to expire where they've got nowhere to go if the closing doesn't take place. So I guess the question is to try and think about constructively when disclosure works and when it doesn't work, rather than saying we have to throw out the baby with the bathwater. If there is a baby here, yeah. I think there may be a baby here.
Right. Okay. So this is just a technical point, but contracts between clients of lawyers and lawyers are not usually considered as consumer contracts. These are, for some reason, lawyers are, maybe good reasons, in many consumer protection acts are exempted, and they are not subject to the same requirements as other businesses. But that's not it. Of course, you're right. There is a transaction in which information that seems valuable needs to be given. I would be interested to see how this information is delivered. Question that was suggested before, is it that the lawyer will sit the client and say, you should know that I was, unethical before, did really terrible things. Surely that's not how we think it works. And so maybe when you sign the contract, retainer, agreement, whatever it is, there are all sorts of papers, and in one of them there is also this disclosure. More likely, I haven't seen it, and I have exactly how this occurs and what is the language of the disclosure, but it could very well be that. In which case, I would say it's a good idea to have this disclosure. It could help. People want to know this information, and you can imagine how it gets, but maybe it's not done very well. Now, peanuts. Surely, what can be said to suggest that that's not a good disclosure? It's a great disclosure. You wonder whether it would be disclosed voluntarily. There are lesser issues that people care about food that are not regulated and are disclosed. Or the absence of disclosure tells you that there's something that that you don't like in the food. So there was a big debate, and I think it was a case in Vermont, where a consumer group wanted to ask that the state regulate milk packaging, whether the cows were treated with the growth hormone that's called RBST, and the response was that this was impossible. It was a preemption issue or something of the sort. And they claim, we want to know. We have the right to know. It is important to us whether that was true. And we want this mandated, that they have to not hide it from us. There is no regulation. Now, every package of milk nowadays that is used, because consumers care about it, and it's important, if it is cows that were not treated with RBST, there is a big label that says non-RBST. And if it isn't, if there is no such label, everybody that cares about it knows that RBST is involved. So the information is delivered through this kind of unraveling. You either say that you have the good property, or if you don't say anything, we assume the worst. You can imagine that without peanut regulation, peanut disclosure regulation, you would have a similar unraveling result. With another class, with a food law group of students, Professor Baird and I looked at what happened when the government started regulating labels of organic and fresh foods that you have if you want to make a claim. People care about it, not as important as peanuts, but it is important to many people, and it was a nightmare. Everything now that says organic, it turns out not really organic. There are all sorts of things. It's regulated, meaning that most of us don't know. Did you know that when it says organic, it's only 95% organic under the regulation that were promulgated by the federal government? We didn't know that, and before it was regulated, the term organic maybe was kind of free for all, but there was some sense, the situation wasn't worse than it is now. And so I have to say I'm skeptical even about these kind of easy examples where disclosure probably works. One more. Yes.
You mentioned healthcare, and I was actually very relieved when you mentioned informed consent, just because I was thinking that I completely agree that for a patient, getting an awful lot of information, in some instances it can just be the doctor kind of abdicating responsibility by saying, look, I warned you, so you're forewarned, you've assumed the risk. But I was also thinking at the same time, it seems pretty different from a lot of other product choices, in the sense that what is being disclosed by the doctor is much, much more subjective. It has to be tailored to the patient. So for this patient, there's more of a risk of hypertension or some other side effect. And also the timing of the disclosure is much more dependent on what the patient has told the doctor. So the information is asymmetrical both ways. I mean, yes, the doctor can do tests to verify, but for some things you're not going to actually see. So given that, it seems like there's a very different context in how you will make a decision of what package of incentives or regulation, whatever remedy that you would set out. And I'm sure there must be other kind of subcategories. So when you're talking about remedies, are you coming up with kind of subcategories, and what might they be of what these better remedies are?
So I think that the discussion of how a doctor tailors the advice to the patient is not exactly what the informed consent movement in medical services is. The informed consent idea is, the way it is practiced, is those forms that you sign, or the doctor telling the nurse, would you please consent him, this patient? it's a standardized way to kind of go through things that are totally not informative. And that you can see, doctors give advice to patients. That's what the patients go there for. It's not necessarily what the informed consent is focused on. Informed consent is, beyond it. You should know that there are risks and there are probabilities. Some things are, it's unlikely that this will happen, but you should know. And there's another thing that is very, very unlikely, and you should know. And then there is something that is extremely unlikely, but you also, just to get your consent and sign to this. I think that, again, is just a ritual of meaningless, a meaningless ritual. Nothing, it doesn't help at all. Whether there are other remedies that could help patients, I'm not saying, throw away tort law for negligent advice you get from physician. I was trying to suggest at the last part of my presentation that maybe not so much, I'm not sure how it would work in the medical context, but relying on other devices to protect us, such as ratings, such as carving the transaction in a way that would give us way out when we're not happy, rather than long-term commitments, is a more promising way.
Well, first I have regards from Ronald Coase himself. I had the good fortune to have lunch with him today. When I described the lecture and our disappointment in not seeing him in person, he said, well, I hope that your lecturer today isn't like most of those young people, but he's somebody who actually goes and reads contracts. So I was very happy. I'll be very happy to report back that we actually had some contracts read to us in the spirit of Ronald Coase. Thank you very, very much, Professor Ben-Shahar, and I know that you'll be able to answer questions